Hey everybody, welcome into the back room. I'm Andy Ostroy. We have Geoffrey Corn with us today. We'll chat with him in just a moment, but first, thanks for tuning in. We appreciate you listening, and we'd love to hear your comments. So email us at backroomandy@gmail.com and or post on our social media, and we'll read some feedback next time. And if you like the podcast, please rate and review and follow or subscribe, and you'll be notified every time we post a new episode. So, Geoffrey Corn is the George R. Killam Jr. Chair of Criminal Law and Director of the Center for Military Law and Policy at Texas Tech University School of Law. He's a retired U.S. Army Lieutenant Colonel who served as both an intelligence officer and a military attorney who culminated his career as the Army's Senior Law of War Advisor. He's co-authored several books, including The Law of Armed Conflict, An Operational Perspective, U.S. Military Operations, Law, Policy, and Practice, and National Security Law and the Constitution. Geoffrey, welcome into the back room.
Nice to be here, and thank you for inviting me.
I want to start with the subject of JAGs. We lay people have heard the term JAG many times over the past year. It's not a term most Americans were familiar with. You served as a member of the Judge Advocate General's Corps. What exactly was the role you served in particular, and how does that differ than the role of a JAG itself?
Well, I served in a variety of positions as a JAG officer. JAG stands for Judge Advocate General. Mm-hmm. That's the top lawyer for each branch of the U.S. military service. So the Army, the Navy, the Air Force, the Marine Corps. They have the, with capital T-H-E, the Judge Advocate General. Mm-hmm. So if you think about it, that function is twofold. Number one, that's the principal legal advisor, the general counsel, if you will, to the chief of the service. So the chief of staff of the Army, the Judge Advocate General is his principal legal advisor, but also the head of a law firm. And the best way to understand what a JAG does is to think of a military installation as a small city. But instead of a mayor, the commanding general is running the city. And like any mayor, the commanding general has a huge array of legal issues. There's crime on the city, so you need prosecutors, you need defense counsel, public defenders. There are issues of damage of property, or people get hurt in an accident, so you need claims adjudicators and a claims process. There are service members who need legal aid. So you've got to have a legal assistance office. There are all sorts of administrative law challenges, everything from environmental compliance to labor and employment disputes to how to allocate certain funds in accordance with federal statutes. So you need an administrative law section. Every military base will have usually a colonel, or sometimes if it's very small, a lieutenant colonel, who is the senior lawyer for that commander. That's called the staff judge advocate. And the staff judge advocate will have a JAG office that has functional sections that deal with all those different problems. When you come into the Army or the Navy or the Air Force as a JAG officer, you start very low, and you will bounce around from those different functions. So over the first 4 or 5 years, you'll probably do a year in legal aid, maybe some administrative law, then you'll do criminal prosecution or defense, and you progress through your career that way. Sometimes as you move up in the ranks, you get to the level of major or lieutenant colonel, then you become more of like an office manager in one of those offices. The one thing that JAGs do that a general counsel for the city of New York wouldn't do is they also have to provide what's called operational law advice. That's advising commanders on rules of engagement, laws of war, detainee treatment operations. If the unit deploys into an operation, the legal issues don't stop. You still have all those other legal issues. Soldiers commit crime. A soldier will be deployed to Syria and get a summons for a court appearance and needs some lawyer to write a letter saying, I can't appear because their family will break up and they need help with a divorce settle, whatever it may be. But a unique function of JAGs is being able to advise commanders on military operations, the conduct of operations. That's what JAGs do. JAGs are licensed attorneys who graduated from ABA accredited law schools. It's very competitive. to get selected to be a JAG officer. Most people don't know this, but I have students at Texas Tech University whose odds of getting selected to be a JAG officer are about the same as getting selected to be a federal law clerk. So they only accept about 8% of applications. So they're highly qualified lawyers. One thing I think a credit to the JAG Corps, the selection process is not obsessed with academic pedigree. In other words, they're not all from Harvard, Yale, or Columbia. They deliberately try and get a very well-rounded candidate. They'll take applicants from every law school in the country. It's a very diverse organization. And it's a great place to start a legal career. You're self-sufficient. You have lots of challenge. You get a lot of responsibility early on. That's what JAGs do most of the time. What people hear about in the media, for example, with the boat strikes in Venezuela, is was there a JAG involved? Now you're talking about a different level. Now you're talking about the legal advisor for the chairman of the Joint Chiefs of Staff, the colonel or the Navy captain who's advising the Southcom commander, or the Joint Special Operations Command commander. Those are lawyers who've been in the service for 20, sometimes longer, years. They've done all those other jobs, but they've kind of matriculated into a specialty of operational legal practice.
And there's been a lot of changes on that senior most level this year, right? With the moves that Trump and SecDef Hegseth have made. Speak to that a little bit and how those two in particular have really changed the landscape for JAGs. And I'm also interested on the much lower level, and maybe this is a difficult question to answer because you may not have the statistics for it, but maybe it's just opinion. Are those entry-level spots as coveted right now as they used to be, perhaps, given what's happening at the Defense Department?
Well, I'll take the second question first. I think so. And I think that's because most of those applicants, you're a law student, you're a second or third year law student, you're interested in being a military lawyer, maybe for 4 years, maybe for 30 years, who knows? They recognize that their daily practice is not going to be particularly impacted by what's happening at the highest level. When I was a JAG captain at the 101st Airborne Division, back in 1992, I knew who the Judge Advocate General was, but, only because he came to graduation at the JAG school. That was not my world. I was sawing the wood in front of me. And I think most of them realize that there's still great honor in serving the institution and serving the soldiers and commanders who do the hard work for the nation in the military.
But just to play devil's advocate just for 1 second, I'm sure in that moment when you served on that level, you weren't thinking like, well, my commander-in-chief and the SecDef are like invading countries just to steal oil. Like,
no, I wasn't.
You didn't have those issues to contend with.
No, but I mean, it's not to that extent. But as an example, back in 2001, I was the chief of international law for the headquarters of U.S. Army Europe. I was lieutenant colonel, and we started detaining people in Guantanamo. We started capturing them in Afghanistan. Nobody knew how to characterize them. It seemed simple to me. I saw all of the legal opinions saying that this is a new enemy and we don't have to follow the rules of war. And Alberto Gonzales was talking about the Geneva Conventions as if they were antiquated. And I had junior officers who I had taught at the Army JAG School contact me and say, I don't understand what's going on, what's happening here. And I remember the first plane load of detainees that we sent from Afghanistan to Guantanamo had to transit through Ramstein Air Force Base in Germany. And pictures got out of them chained to the floor. You may remember this.
Absolutely.
They were chained to the floor. And I mean, I have to say that all I could say to my subordinates was, there may be more to this than we don't know. Because on its face, it didn't seem right. And so I don't think to the extreme we're seeing now, But I think there have always been moments where, as junior members of the firm, you're kind of scratching your head and saying, what's happening up at the top with the senior partners? But to go back to your first question, what happened when Hegseth came in? First off, he came in with this kind of imprimatur of being completely dismissive of the role of JAGs and the role of law in the regulation of hostilities.
Yeah, he called them jagoffs.
Called them jagoffs. He had this whole thing about how rules of engagement are stupid, and his book about how military law or international law had hobbled the effectiveness of the military. Now, that's first off, that's just not true. It's a lieutenant's view of the strategic significance of respect for international law and the conduct of military operations. I was a lieutenant. I didn't start in the JAG Corps. I understand that perspective. When you're at that level, you want to be unconstrained. You want to be able to do whatever you need to do. You care about your 40 soldiers that you're responsible for, and you want to be able to unleash your combat power at will. But you can win a battle and lose a war in a second. Anybody who has any doubt about that just needs to look at, the widespread condemnation of the Israeli Defense Forces, which I've defended because I think, in fact, their compliance with the law has been through the Gaza campaign was pretty good, but it didn't matter because it was perceived as overbroad, excessive, indifferent to human suffering. And they may have been tactically brilliant, but strategically it was a disaster. And so I understood where it came from. The problem is I have on my desk these desk side reminders that a colonel gave me once that he told me he got from Colin Powell. And the first thing it says is leader actions are exaggerated and emulated, right? And that's what the concern was, do you really want a message to Sergeant Jones and Lieutenant Brown that they don't have to worry about the law? Is that really the right message to send to them when they're operating in these extremely complex operational environments against enemies that want to create the perception that we don't care about the law to gain strategic information advantage? And then when he came in and he immediately dismissed the Judge Advocate General of the Army, who, by the way, Joe Berger, 3-star general, career JAG officer, West Point graduate, military police officer in Mogadishu. Anybody who's seen Black Hawk Down knows how hard that mission was. Legal advisor to Special Operations Command when they conducted the raid that killed Osama bin Laden. I mean, this guy was not just highly respected, he was experienced and thoughtful and deserving of the position, and unceremoniously thrown out. I mean, he found out from a friend through an email that there's been a tweet that you've been fired. And he literally went in over the weekend and cleared out his office. That, I think, sends shockwaves. Like, what's going on? I don't know the officer that was appointed to be his replacement. I do know he was a colonel in the National Guard, and I have great respect for the National Guard. But, I mean, candidly, if you're going to put somebody in charge of a law firm who's been working on weekends once a month, when you've got 1-star generals sitting in the office who've been in the organization for 25 years, I mean, you have to wonder. The perception was, at worst or at best, maybe a great honorable guy who might not have the institutional depth and experience to be running the firm, so to speak. At worst, selected because of an inclination to be not, remember what Hegseth said? I don't want roadblocks. Well, guess what? The role of a lawyer in any institution, especially as a counselor, as an advisor, is to identify roadblocks. I had a JAG general say once he had a bumper sticker. He borrowed his daughter's car, and there was a bumper sticker on it that said, "Question authority." And he parked in the general parking lot at the Pentagon, and another general looked at him and said, do you really think you should be driving a car with a bumper sticker that says question authority? And he said, I stopped for a minute. His name was Brigadier General Barnes. He said, I stopped for a minute and I said, yeah, I'm a JAG. That's my job. Question authority. Now, if it said challenge authority, I might not be cool with it. But that's what we're supposed to do. We're supposed to speak truth to power. The ethical obligation of a JAG is to represent the client. The client is not the Secretary of Defense. It's not the president. It's not the commander. It's the nation and the institution. And like being a counsel, a lawyer on a corporate board, sometimes the decision of the CEO is incompatible with the obligation towards the shareholders. Mm-hmm. It's the same principle for military law.
Yeah, but what's happening here is that it's the psychological pathology of it all is just so twisted, because when you say question authority and you speak to the role of the JAGs, that only works if the people at the top, the person at the top, respects and appreciates that counsel and has the capacity to go, maybe I was looking at this the wrong way. Now, we know that Trump can never be at that place, and clearly Hexeth is not there either.
Well, I think that's true, and I've published a number of editorials critical of the decisions related to what's happening in Venezuela. I'm working on one right now, explaining how any military seizure of Greenland would violate the most fundamental principles of international law.
How does someone like you, who has served, not just in the military, but has served as someone who is in this advisory council capacity on specific military actions like this, when you hear that the United States, through obviously the president, is contemplating, however serious it is or not, which is a whole other question, is contemplating invading a NATO-held territory. I mean, it's like the Twilight Zone. It must make your head spin.
Well, it's very discouraging, I'll say that. It's depressing. And I would say, there but for the grace of God go I, in terms of the senior JAG officers that might have to contend with that might have the chairman of the Joint Chiefs go to them and say, we've received a warning order to take over Greenland. What am I supposed to do? I think...
Would that be an illegal order?
It would unquestionably violate international law. Let me say that. There'd be no room for debate. There's been, I would call them outlier legal experts who've made arguments to justify what happened in Venezuela, what's happening in the Caribbean. There's no credible, zero plausible, credible international legal authority for doing what the president is doing. As a matter of fact, the Charter of the United Nations, which is supreme law of the land because it's a treaty we're a part of, it doesn't just prohibit the use of military force against the territorial integrity of another nation. It prohibits the threat of military. So we're already arguably violating international law because we have the president threatening a military invasion to annex Greenland. And then you have the whole problem of the annexation would be illegal, would violate the Fourth Geneva Convention, one of the only 4 treaties that have been universally adopted in the world. I mean, I think, I can't be sure because we cannot be in their heads. I think you would probably have some very senior generals or admirals resigning at that point.
Is that a good thing?
I mean, it's not a good thing that a commander-in-chief or a president of the United States would order a military action that is so legally dubious that it would lead to subordinates feeling that they had no other option other than to resign. I mean, that's terrible. Terrible. And one of my biggest complaints about some of these military operations, not all of them, by the way, I actually co-authored an op-ed when he ordered the attack on Iran that said I think that it was legally justified and I felt he acted constitutionally. So I'm not, I get emails I publish these op-eds and I get emails from people saying, you just have Trump derangement syndrome and you just hate everything he does. And I said, well, if that's true, then why was I writing the op-ed in the Washington Post that said his action in Iran was a lawful act? But my biggest complaint is that I think when the nation orders a man or woman who's volunteered to serve in uniform to use lethal force against another human being, to kill somebody, that individual is entitled to moral clarity, because that's not an easy thing to live with. And anybody who thinks it is deluding themselves.
And strategic clarity.
But start with moral clarity. I think that's what they deserve. And I never shot at anybody, and I'm glad I never did, because I wouldn't want that. I contemplated it a few times in Panama, and I knew that I would have been doing the right thing. I would have been doing my duty. I would have been doing the right thing, because I had that much confidence in the leadership I was operating under. When you push the military into areas of legal uncertainty, the more legally uncertain an operation becomes, the more morally confused it becomes. And I think that's unfortunate. And so the legal clarity that JAGs help leaders identify has not just, as you say, strategic value, it has moral value. It has leadership value. I cannot imagine he would order, I know everybody's going to say there's so many things you can't imagine. I just don't see it, unless he is hell-bent on destroying NATO. And this is the way to do it, because there would be no material difference between us taking over Greenland by force and Putin taking over Crimea by force.
Exactly.
None.
Well, is it more that he wants to destroy NATO, or that he doesn't even understand or appreciate what NATO is? So, for example, his justification has always been that we need Greenland for national security because China can come and blah, blah, blah.
Got it.
Well, that's what NATO is for, literally, right? Like, it's literally what NATO is for, to ensure our national security against incursions like this. And so, to me, it's just more of his general ignorance of things.
I'm not qualified to answer that question. I mean, that's not a legal question. We all have our views on that. I don't know. I do know, I know people who have briefed him, and I've asked them what the experience was like, and they've said he's very different behind closed doors. He's thoughtful. He's inquisitive. I'm like, I wish I saw that externally. I think there's an enigmatic aspect to him. Who knows? Maybe it's just that he put it out there. Everybody said you can't do it. And he's driven so much by his ego that he says, dare.
Well, neither of us are psychologists, but I think you just hit the nail on the head.
I don't know. But I don't think, I think what would happen is there would be a warning order to start planning for this. And then he would start getting tremendous internal pushback. I think General Kane would go to him and say, all of my lawyers have told me that this would be a catastrophic move. It's a blatant violation of the UN Charter. It would make us an occupying power with all the challenges and problems. And if we go to annex it, even worse, because unilateral annexation is another clear violation of international law. And I think Kane would probably tell him, if you issue this order, it's going to create a real dissension. But I don't know. We don't know. I mean, what we do, I do think there was some pushback on Operation Southern Spear, the boat campaign, but ultimately there was you have the Attorney General issuing a memorandum that says, here's why we think it's all legal. And then if you're a lawyer in the general counsel's office at the Pentagon or in the chairman's legal, you're kind of stuck with that. You can object to it. You can push back against it. But in the end, once they say, we've heard your concerns, this is the government's legal position. By the way, one of the first executive orders they issued included a provision that says the Attorney General is, in essence, the Supreme Court for the executive branch. What the Attorney General says is the law, and the interpretation of the law is controlling. So I have no doubt that if from what we've seen so far, that if President Trump says, I want to do this, that the Attorney General would have lawyers come up with some absurd legal theory on why we're allowed to do it. But I think it would be so absurd that at that point, the lawyers in the Pentagon, the senior lawyers, at least the uniform lawyers, would go to their clients and say, their commanders, and say, this, I just can't. I mean, it's unethical for me to embrace this. And I think the order, you have an obligation to object to the order if it comes.
Yeah, I mean, this is, again, more of a psychological thing, but I have this theory that because of the ego issue that you brought up before, and also this desire to project machismo, which I think Hexeth has as well, I think with Trump, he's more into a series of one-offs, which sort of keep him from engaging us on a longer term. I'm curious to know what you think about his shift in tough talk on Iran this week. You know, he drew a red line, and all of a sudden, like, not only is he claiming that people aren't getting killed in Iran anymore, but he's taking credit for, like, his tough talk stopped the killing of Iranians.
Maybe it had an influence. I don't know. But what we don't know is what happened behind the scenes, right? Mm-hmm. So you've got the Senate at that time was debating a resolution limiting his constitutional war power, which would have had no real legal effect but it has a political effect. It's telling him the Senate's getting uncomfortable with your military adventurism, so to speak. Mm-hmm. And so, I mean, you already have the War Powers Resolution, which is a law, and it has no real effect anyway. So now you're getting, not just from an international law standpoint, but from a constitutional law standpoint, what is the limit, if any, on the president's authority to unilaterally decide to employ American military force? Notice that the whole thing in Venezuela, the boat strikes, were always framed in the rubric of self-defense.
Right.
Right now, I think that's invalid, but that was constitutionally significant because there is established authority that the president has authority to use military force to defend the nation against an attack. I don't think drugs are an attack, but that's my opinion. And then the Venezuelan raid, what was the characterization? Law enforcement. The president has authority as the chief executive to direct federal agencies to apprehend suspects abroad. Okay, but when you get to Iran, what's the authority? It's not law enforcement. It's not self-defense, like the attack on the nuclear facility. That you can argue is an act of self-defense. It's just initiating hostilities with another nation. And I suspect, maybe I'm wrong, but I suspect that he may be influenced periodically when the lawyers in the administration, as supplicant as they may be, it limits and say, this is not the right time for another military adventure, especially when the Senate's debating this Venezuela thing now. I don't know. But you asked initially, how does it make me feel as someone who has practiced and studied constitutional war powers, international law related to the authority to use force? It's very discouraging, and we are losing respect in the international community faster than the way I think of it is he's squeezing out toothpaste that we're not going to be able to put back in the tube. Mm-hmm. Who's going to trust us in the future? Even if there's a new president and the president says, I want to get back to alliances, then you just have to, if you're Japan, if you're Europe, if you're Lithuania, Latvia, Estonia, Poland, Norway, Sweden, you're just thinking, what about the next election? And that loss of trust and confidence in the commitment of the United States to allies and the general commitment to respect international law. Okay, I get it. You'll have listeners who say the U.S. periodically violates international law. Here's the way I would characterize it. There have been times when we have pushed the envelope with international law. I have been an advocate for that. I was one of the strongest early advocates for treating the response to 9/11 as an armed conflict. Okay? But there's a difference between pushing the envelope and shredding it. And I think the perception is growing increasingly that this administration is shredding the envelope of respect for international law, and with the attitude that who cares, it's just international law, it's soft law, but it matters. And it's going to matter in the future. And it's going to matter for coalitions and alliances and arms control. I mean, put yourself in the position of one of these allies who can no longer have confidence that the United States is going to support them against a nuclear armed opponent. Do they now have an interest in arming themselves with nuclear weapons? Japan, how hard would it be for Japan to acquire a nuclear weapon? The Philippines, the Baltic states, the Nordic states. I mean, the insurance has always been trust and confidence in the United States. And that is being eroded. And I think that's very unfortunate.
Well, it's also true what you said. And it's because, unlike the reaction to 9/11, the Patriot Act, all this stuff, like, we had a legit reason to do that stuff. Whether people agreed with the specific tactics or not, it was, on most of the level, rooted in a sound strategy to defend this country from this enemy called terrorism. Today, it's like, if you're the prime minister of Japan, or if you're, heads of the NATO countries, you're sitting there thinking, he just wakes up in the morning and goes, what shit should I break today? That's how policy's getting made and decisions are getting made. And it's like, what's happening here?
Let me play devil's advocate. He gave that interview to the New York Times where he said, international law doesn't constrain me. And I don't have to worry about it because I just don't want to hurt people. It was an interesting comment. So I'll play devil's advocate. Take that characterization you said about terrorism, newfound threat, endangering the American people. So that's exactly the reason why there are some people, and probably a good percentage, who support this counter-drug military campaign. You say, well, narco terrorism, new type of threat, hurting American people. Yeah. You got the military, why aren't you using for it? Or Iran, right? If I can imagine an instinct, if I were the president, that if I've got the capability to help these people stop getting massacred, I want to do it. I mean, it's complicated.
Well, it's complicated. I'll play devil's advocate now. If you're advocating for the rights of protesters in Iran, at the same time, you're calling protesters in the U.S. terrorists. I mean, I get it. But the problem is you open up a Pandora's box because you're making a subjective judgment that intervening in Iran is a worthy cause. Well, that's exactly why Putin invaded Ukraine. Because he said Ukraine is an imminent threat to the Russian people, and there are Russian nationals in Ukraine that need our support. This is how World War II began. I mean, people forget that it began with the Anschluss of Austria, because, of course, the Austrian government wasn't taking care of Germans well enough. And then the Sudetenland, there was a large German minority. It was a humanitarian intervention. And the whole effort after World War II was to say, we're not going to allow states to make those unilateral judgments anymore. There has to be collective action. And I know the system's not perfect, the system of international law, but we have not had a catastrophic war like World War II since we implemented that system. People, it's almost mind-boggling. I just finished a book by Rick Atkins about World War II, and I didn't know this statistic. For every single day of World War II, for 6 years, 30,000 people died. Every day for 6 years. We have not experienced a war of that cataclysmic level, and I think a big reason was because we rejected the idea of giving states kind of this unilateral authority to decide when it's good or not good to use force. And we've mitigated interstate hostilities. So you can't just throw that out. The other thing I would say is that with him, my perception is that he likes the military as a tool.
for a variety of reasons. One, because of the powerful presumption of obedience. Number two, because of their competence, their efficiency in getting things done. So if your favorite tool in your tool belt is a hammer, then instinctively you start making every problem look like a nail. So drug problem, complicated international law enforcement problem, probably a lot better ways to do it than we've been doing it. But why go through all that headache? Just call it a war, and now I get to use the military. Iran, complicated diplomatic, political dilemma of people trying to gain self-determination and throw off the cloak of a unquestionably pernicious regime. Well, maybe it's just easier to bomb them. So border is a problem. I want more enforcement on the border. Hey, I'll just expand military installations along the border. Now I get to use the military. Domestic disturbance. People protesting the actions of ICE. What's he threatening now? I'll just invoke the Insurrection Act and deploy the National Guard deployment. So every problem starts to look like a nail because your instinct is my favorite tool is the hammer. And, that I think that explains a lot of the Nigeria thing is a good example, right? He's in Mar-a-Lago, he's sitting at a table. Someone says to him, there's a genocide against Christians in Nigeria. Oh, we can't let that happen. Who can we bomb?
I laugh because I think it's all insanity. And I agree with everything you just said. I think, though, a lot of people would say he goes out and buys all the nails and then dumps them all over the world.
Yeah, he starts the fire so he can put it out.
Yeah.
Listen, there is here's what I would say, because I teach what we call national security law, which is really about constitutional separation of powers. I have a co-authored book on the topic. Nothing he does in terms of asserting power, unilateral power, surprises me. He signaled all this in his campaign.
Yep.
We know from Mark Esper, from General Milley, from Mattis, from McMaster, from Bolton. We know what all of his instincts were in the first term that were restrained by these rational thinkers, correct? The real failure here is Congress.
Absolutely.
Because Congress's job in the relationship of separation of powers is to check aggrandizement of power. Mm-hmm. There's a great, maybe the most significant Supreme Court decision on separation of powers ever written was called Youngstown Sheet and Tube versus Sawyer. It was during the Korean War. There was a major strike in the steel industry of the United States. And President Truman had a problem because he needed the steel for war production. And he wasn't able to get the labor and management to settle the strike. So he ordered the Secretary of Commerce, Sawyer, to seize steel industry. Like, he issued an executive order and he says, I'm ordering you to take over the industry and get people back to work. And unsurprisingly, the owners of the steel mills sued him. And it went up to the Supreme Court. And the Supreme Court looked at a law that Congress had enacted called the Taft-Hartley Act, which is still in effect. And in the deliberations on that law, the president had asked Congress to give him emergency seizure authority, and they had refused to do it. So a majority of the justices said, look, he can't do it because Congress essentially put in the law, you're not allowed to do this. They didn't, by not including that provision. In his concurring opinion, Robert Jackson, one of the greatest justices of the court, Robert Jackson was a real pragmatist. He had been Franklin Roosevelt's attorney general at the beginning of World War II. He was also put on leave by Franklin Roosevelt to be the chief prosecutor at Nuremberg. He understood abuse of executive power. And he also understood that presidents are often challenged by wanting to do stuff that they're legally constrained in doing. And he rules against Truman. He says none of the powers in the Constitution let you ignore Congress here. But at the end of the opinion, he says, I'm not naive. Nothing this court says can stop power from slipping through the hands of Congress if it's not wise and timely in meeting an emergency. Because while not law, there is good wisdom in the maxim attributed to Napoleon, the tools belong to the man who can use them. And if I were putting a sign over the White House, it would be that maxim. The tools belong. So, of course, the president is going to see a problem and say, here's what I want to do, and push the envelope. And if Congress is acquiescent or compliant or apologetic, I mean, everything he does, the Republicans come out and twist themselves into pretzels to say why it's justified. Mm-hmm. He's going to keep running.
Yeah. Well, so, in that New York Times interview that you cited before, and the thing he said that you were alluding to before, he literally said, in response to the question about how limited is his power, he said, my power is only limited by my own morality, which correct. I found terrifying. Chilling. Because this is a guy that has zero morality. So if that's how he sees his power and his job and the world, then your point about Congress is just so much more critical. And that's where the crisis in this country is today. You know,
no
if we're moving towards autocracy, it's because of Congress. No, they can get rid of him tomorrow.
It's not just get rid of him. They can check him. They can put limits on him. Look, if we're being candid, there are problems he identifies that are legitimate problems. As you say, we probably do need a much more robust defense presence in Greenland. Fine, that's a legitimate issue. It's always the way he proposes to do it that's problematic. Drugs coming into the country are a problem. We need better enforcement on the high seas. I think most people, most Americans agreed that the border was a problem. But the way in which he and this is no epiphany. I mean, this is David Brooks has written on this repeatedly. Acknowledge the legitimacy of the complaint, attack the manner in which it's being addressed. And I think that's Congress's role. Congress's role is to say, if you see a problem, it's not just your prerogative that decides how to deal with it. You have to involve us, and there has to be a cooperative process. You know, we teach in high schools and middle schools that the genius of the founders was separating power. No, it wasn't. They separated authority over shared power. That was the genius, right? Think of war power. They deliberately allocated some war power to Congress and some war power to president to force friction, because through that friction, they were convinced the results would be better and liberty would be preserved. And when Congress abdicates its role in immigration, in war powers, in domestic law enforcement, in international drug enforcement, when it abdicates all those powers, it is contradicting the logic that the founders built into the text of the Constitution itself.
Last question. You mentioned the Insurrection Act. Talk to me about the legality of that. And he probably would invoke it, but how quickly might that be put down by the courts?
Oh, no, it won't be put down by the courts. If he invokes the Insurrection Act, it will be upheld by the courts. People need to understand what it is and it isn't. Okay? The constitutional drafters had an aversion to the interference of a standing army in domestic affairs. That was one of the causes, if you read the Declaration of Independence, that was one of the causes for the rebellion. And they put certain provisions in the text of the Constitution to limit the role of the military domestically. I think one that is fascinating and most people don't know is that they restricted Congress's appropriation for the Army to 2 years, right? Now, if you think about it, what happens every 2 years? There's a new Congress elected, a whole House of Representatives. Who has fiscal power? The House of Representatives. Appropriation bills have to originate in the House of Representatives. So I think they were thinking, if Congress creates an army and the president starts abusing liberty with the army because he's the commander in chief, he can't pay him after 2 years. And then there'll be a new Congress that will come in and can check that power. After the Civil War, because of the perception that the military was getting too involved in Reconstruction law enforcement, Congress enacted a law called the Posse Comitatus Act. A Posse Comitatus just means that the local sheriff calls all able-bodied individuals into service of law enforcement. The Posse Comitatus Act prohibits the use of federal military forces as a posse comitatus unless authorized by the Constitution or a statute. So, Posse Comitatus Act means that as it's been interpreted, the president cannot deploy active duty military forces for law enforcement purposes. He can support law enforcement. They can provide surveillance, equipment loan, training, but direct involvement in law enforcement is prohibited. The Insurrection Act is a statutory exemption to the Posse Comitatus Act. So by invoking the Insurrection Act, the president is invoking the authority to use federal military forces in a direct law enforcement role that would otherwise be prohibited. Once he does that, they can then engage in law enforcement activities to enforce federal law, but they're under the same rules as any other law enforcement officer. It doesn't mean you can go out and start shooting people. They are subject to the same constitutional constraints on use of force, search and seizure, et cetera, which is why, by the way, active duty military commanders are not fans of this deployment.
Given what we're seeing in Minneapolis, ICE is clearly acting not within the framework of the law 100%. Do you think Trump understands what you just said? Or in his mind, I invoke the Insurrection Act, I can do whatever the hell I want with these troops?
I don't know what he understands, but I know clearly that if anybody thinks that they can just go out and start summarily rounding people up and shooting people and putting them in detention camps, and they're wrong. The courts will intervene in a heartbeat to stop that. What the courts will not do is strike down invocation of the act, because the way it's termed is very broad. All he has to do is make a finding that a civil disturbance has interfered with the ability to enforce federal law, and he can unilaterally invoke the act. Now, historically, the act has been invoked when state governors say, we need help, we're overwhelmed. The last time it was invoked was in response to the riots after the acquittal of the police officers that beat Rodney King in Los Angeles. But presidents
and they were invited in by
the government.
The government.
By the governor. But presidents have done it unilaterally during the civil rights era, when Southern governors refused to enforce court orders protecting federal rights. Presidents have invoked the Insurrection Act. It wouldn't shock me if these protests continue in Minneapolis that he invokes it. I think he's been itching to do it. Yeah. He was ready to do it during the Black Lives Matter protests in Washington, D.C. Matter of fact, my understanding is that they flew a battalion of paratroopers from Fort Bragg to Andrews Air Force Base, and they were ready to go. And it was Mark Esper, if you remember, I think in a moment of honor, where he went on television at the Pentagon and someone said, we understand that the president is thinking of invoking the Insurrection Act. And Esper said, there is no justification for invoking the act. We don't need to do it. And of course, Esper got fired after that.
Yeah.
But you don't have anybody in the administration that's going to say no to it this time. So I wouldn't be surprised if he invokes it. People think, well, if he invokes the Insurrection Act, that means there's martial law. That's wrong. The courts are not going to allow the military to take over the law enforcement function completely unless there was some catastrophe that disabled all civil function. So there's a lot of misunderstanding about the law, but I wouldn't be surprised if he invokes it in the next week or so. By the way, it's a test case, right?
What's that?
If I can get away with it here, maybe I can get away with it later. For example, during the midterms, if there are protests about something going on with an election and something's being stolen, and I'll get it's a mess. But again, when your favorite tool is a hammer, every problem starts to look like a nail.
Fascinating insights, chilling nonetheless. Geoffrey, thanks for coming on and sharing them with us. And I do hope you'll come back and chat with me again sometime.
Anytime.
All righty.
Bye-bye.
Take care. This episode was produced and edited by me, Andy Ostroy. It was co-produced by Maddie Rosenberg and Jen Hammoud for Radio Free Rhinecliff, with additional editing by Maddie Rosenberg, music by Andrew Hollander, and graphic design by Cricket Langell. And with a special thanks to our sponsor, The Epicurean. Again, thanks for listening. Please rate and review wherever you get your podcasts, and subscribe to the Backroom with Andy Ostroy YouTube channel, where you can watch full videos of our interviews. See you next time.